it would involve phone calls, etc. And I guess the bottom line is because they were not written communications. And if we were to use your regular communications, that means we would have had to write to these institutions. First, the time it will take for these communications to get to them, and secondly, time was of the essence. We needed to act, and we needed to act immediately and decisively. And so those regular communications really weren't the best option at that time. But secondly, yes, we could have involved wildlife and livestock in the discussions before the application. But don't forget that we are not dealing with individuals here, we're dealing with departments. And the risk of information leaking out in those departments was real. And it's like I said, it's like the police doing a dawn raid, and you inform the neighbors that you are coming to do dawn raid. Then obviously the risk of the suspects getting away increases. And so it did not make a material difference to us in the end whether they were informed before the order or after the order. So long as they were informed and they needed to look for ways to implement this order, that was okay for us. Perhaps for them, if they had had prior notice, they would have put in place the mechanisms to make sure that they take over a sector. That's very possible. But then it becomes a question of balance. Which one do you? So these decisions are not very straightforward. You had to consider the pros and cons of every option, and you make a decision based on your best judgment at that time. And that's what we did. We went for the order. We managed to secure the order, and then inform the parties who were supposed to take over.
Okay. And of course, it is your belief that they were informed, but the fact remains that they were not. They were not informed. And one could also argue that that same fear still lied against Augustus Prom. And one could further argue on that same point that at least these other two institutions were government institutions. Now, if government cannot trust itself, it ought not to trust the third party. Just the proposition. What would you say to that?
In principle, you are correct. If these were normal times, a normal situation, you would be absolutely correct. But the new government was coming in at a time when the old government had spent over 2 decades planting its roots across the entire length and breadth of the government. Trust in government institutions was not at a premium, let me put it that way. Simply because you don't know who you're dealing with. You don't know where their loyalties laid. You don't know who was still sympathetic to the old order. There are all of these issues that you don't see from the outside, but from within you see because you live through it every day. And so yes, we could have informed these two departments. We did not, for the reasons that I have given you. And like I said, if you were to put me in that same situation again now, I would do exactly what we did at that time, because at the end of the day, it's about balancing the different interests. It would have been ideal, perfect, because there's nothing wrong with us informing them beforehand. Ordinarily, it should have been fine. But we were dealing with a situation, we were dealing with a circumstance, a set of events an environment that we weren't even sure about. We're talking about 3 months into the new government. So a lot of things were not very clear to many of us who were coming into the government newly. And because of that, there was a lot of circumspection in our dealings with government offices and personnel, simply because we didn't know who we were dealing with. So it was a very difficult process. You had to work with people at the same time. You don't want to give the impression that you don't trust them, but the reality is you don't know who to trust at that point in time.
Fair enough. So after the order, there was this meeting that we will now refer to as the first meeting of the implementing task force, the implementation task force. So the task force met. What were they meant to achieve in that meeting? From a policy perspective, what were the instructions?
Well, it was to implement the order of the court to make sure that they take custody and control of the different assets that were entrusted to them by the court order. That would have been the primary objective of that meeting.
Now, was there a mechanism put in place? Again, I come back to mechanisms, but a mechanism put in place to track that fact of them having custody of these assets?
When you say mechanism, you mean whether there were efforts to inventorize these assets by these respective?
Well, not quite. The committee is well aware of the inventory efforts, and we will delve into that immediately after this question. What the question is referring to is if the MOJ had put checks in place to verify that indeed these different institutions had in fact taken custody, and that exercise was ongoing.
And what sort of mechanisms would you envisage that the MOJ could have taken to make sure that there was verification in view of?
Perhaps a monthly checkup on each institution, a monthly report from each institution, a verification, a letter verifying from each institution that indeed we have done such and such and such. Because the question has been asked on the backdrop that this order of the 22nd day of May 2017 was time-bound.
Yes.
It was time-bound for a number of days, about 180 days.
6 months.
Right. Now, within those 6 months, whatever activity the applicant had partaken in needed to be reported back to the court. Now, of course, to report back to the court, you have to have the facts. So you would have needed to put in place a mechanism to get those facts in order to report to the court. And that's what I mean by a mechanism.
There are two parts to your question. One is reporting to the court, and the other one is a mechanism for follow-up.
So the question essentially is for the mechanism for follow-ups. However, it's been asked in light of the fact that you would have ought to report it back to the court.
No, not necessarily. There was no obligation to report to the court. Well, yes, the extension would have been a fresh application for extension.
Yes.
But not necessarily to report on the exercise. What you would do typically in an application for extension is to say that you haven't concluded on your investigations, therefore you need an extension.
Yes, but you would agree that that in fact is a report to the court, X and Y and Z.
You could qualify it as a report or as an update on the progress of your investigation.
Then let me dial down the word report to updates.
Okay.
Whatever. They can be used interchangeably in this instance, but please, go ahead.
Did the ministry have the resources, the capacity to monitor these institutions who were assigned the task? Was the ministry under a legal obligation to do so? I think that's the first question, as a matter of fact. The court order was directed at these institutions, not at the ministry, even though the ministry was the applicant. So if the court order was directed at these institutions by the court directly and not through the ministry, what would have been the legal basis for the ministry to continue to monitor the implementation of the court order? That's the question that I am.
All right, so I suddenly find myself on the witness seat. Right? All right.
I'm sorry, I didn't mean
fine.
to.
That's fine.
But I'm just saying.
All right, let me also perhaps speak out loud and say the two parties are the state and the former president. And the state is being represented by the Attorney General, as you had inferred to. Yes. The Attorney General represents the state. Yes. Now, every single institution, except for Augustus Prom, that was bestowed upon assets, is a state institution. Sorry. Now, in case they default and they are to go to court, who is to represent them?
Yes, the Attorney General represents.
It would be the Attorney General.
The government. But so, they have their line ministries.
I understand that. Yeah. However, from my standpoint, it is the government of the Gambia as a bloc that sought for the order, and the court bestowed the order upon the government of the Gambia in its respective institutions, but the responsibility is as a bloc.
Yes.
And so I would actually indeed say that, yes, the Ministry of Justice was legally bound to follow up the order that it sought and report back to the court.
I think we would have a difference of opinion here because, as you rightly say, the government has different components. Ministries form part of the government. For instance, Livestock Marketing Agency is under the Ministry of Agriculture. They were ordered by the court to take over the livestock. Wildlife is under Environment, I believe. Ministry of Environment, they were ordered by the court to take over wildlife. And so they have their line ministries to report to. They owe no obligation, or they owe no reporting obligation to the Ministry of Justice. The Ministry of Justice is the principal legal office of the state. And if the state wants to go to court, it uses the ministry, and that's what we have done. But in terms of supervising and monitoring what other government departments do, I don't think that's constitutionally or statutorily the responsibility of the Ministry of Justice.
When you put it like that, I'm inclined to agree with you. However, allow me to put it a different way. It is the government, through the ministry, who applied for these assets to be preserved. Now, from all indications, it is the ministry who suggested that such and such an institution should be bestowed upon assets. I would stand my ground and say that indeed it is for the ministry to receive those updates from the respective institutions highlighted in the order in order to update the court.
Well, I suppose you're entitled to your opinion, just like we are all entitled to our views. I am saying that if the other departments form part of the government and they have their line ministries, the ministry, in terms of the application before the court, has no option. If the government is going to court, it has to be the ministry that goes to court. That does not mean the ministry takes responsibility for the actions of the other ministries.
The government does.
as the government does. And these other ministries form part of the government.
Of course.
And these departments are part of these ministries that form part of the government.
Indeed.
So the departments report to their aligned ministries. They don't report to the Ministry of Justice.
Yes, but you see, Mr. Tambadou, when there is liability to accrue, who suffers? It is not Gilma. They will not feel a pinch of it. It is not wildlife. They will not feel a pinch of it. It is not Ministry of Justice. You, or the ministry rather, will not feel a pinch of it. It is the government of the Gambia that will feel the pinch. Because
As a whole.
As a block, yes. Yeah. The government would be the one to disperse those funds from any liability.
Yeah.
And that's precisely my point, that governance is a collective endeavor.
Yeah.
And we can't separate the blocks. Yes, the Ministry of Justice is statutorily obligated to be the one to conduct the matters, but it's conducting the matters on behalf of the government. Likewise, Gilma is to have custody of assets on behalf of the government. So you would see the trend that all these institutions are acting on behalf of the government.
But now you want the ministry to supervise the activities of the departments under other ministries.
The word is not supervise. It's to receive updates or to request updates, to monitor the... perhaps the word monitor was interpreted by you as supervision. Not necessarily. But in order for the Ministry of Justice to go back for an extension, it needs to file an affidavit, yes. An application and an affidavit. And the affidavit is just facts. And those facts are not within the Ministry of Justice. Those facts would be at Gilma, those facts would be at Wildlife, and all the other places, perhaps the Registrar General, to relay that to the Ministry of Justice, and for the Ministry of Justice to transmit it to the court.
No, for purposes of applications for extension, because the application is premised on investigation by the competent authority, in this case the Attorney General. And for purposes of extension, perhaps you should look at the applications for extension. I haven't seen them since those days. But the applications would have been premised on the ongoing investigations by the competent authority. So, in other words, there was no need for information from any of these government departments on the assets that they were entrusted with. We didn't need to go to Gilma or Wildlife to get the facts to go to court for extension. All we needed to do is ask the court for an extension on the basis that we have not concluded our investigations. But to now ask these departments to report to the ministry on their activities over these assets is to really put a burden on the ministry that is neither constitutional nor statutory.
You see, Mr. Tambadou, I think this is our first point of conflict. It has come. And I would stand my ground to say, okay, I would disagree with you. If I could relax the scenario a bit, and I could see that from 2000 to 2003, you were in private practice. And you would know that as a lawyer, it is for your client to give you the facts. You cannot manufacture the facts. And even if where you're going to sort for an extension, there's still need for facts to be adduced as to why you need the extension. And the court would not just grant it out of grace. It would listen to those facts and weigh them across the spectrum and grant or deny. Now, the court would grant where the facts lead to granting the application. And those facts, again, are not with the MOJ. Now, the MOJ would need to, let me use the traditional lawyer-client relationship to say that the MOJ is the lawyers, is the law chambers for the government. Now, your clients would be presumably the institutions in the government. They have been asked to conduct certain seizures and to control certain assets. Now, whether that fact of control has occurred or not is a material fact in order for the court to extend its time on the interim injunction. Now, of course, the court would also ask you, or the Ministry of Justice, as soon as the application is made, whether its previous order was heeded too, because we all know, or you and I know, how courts dearly hold their authority and orders. That question would have been asked in court, and it would have been answered by the MOJ that yes, in the affirmative or in the negative. Don't you agree with me?
You see, would have been is very speculative. And your assumption is right. In the ordinary course of things, questions will be asked. But it's only an assumption. But let's find a point of entente, as we say, a point of convergence. If you say that the applications for an extension of the freezing order would have been accompanied or would have been underpinned by facts provided to the ministry from the other departments, I will say that if that is indeed the case, and we have had multiple extensions based on applications, then it means we would have received some facts from these government departments and presented to the court for our applications for extension to succeed. So I am meeting you halfway, counsel, if you like, and say if you are of the belief that there had to be factual basis other than the ongoing investigations by the competent authority, I'll give you those factual basis, because we have applied for extensions and we have received those extensions on a number of occasions, I believe 2 or 3 times. So if those extensions were underpinned by the facts we got from these different departments, well, then it means we have satisfied your theory about what the MOJ should have done.
All right. I was trying as much to follow your response. I can see you agreed with a lot of what I said, but also distance yourself from a lot that I said.
No, I'm just being pragmatic here.
Yes.
If the underlying assumption of your approach is that for us to go to court to seek an extension, we needed to have gotten facts from the departments, and since it was the case that we went and got multiple extensions based on applications, so I am saying by deduction we would have gone, or we would have received the facts that would have allowed us to seek the extensions. So I'm meeting you halfway.
Okay. All right, because this question began when we were discussing the issue of a mechanism of monitoring, whether whether the dictates of the order were actually heeded to or not. And in that spirit, the process in court was basically context. So is the answer to that question that there was no such mechanism?
The Ministry of Justice didn't have the constitutional or statutory mandate, or indeed the resources to engage in any acts of monitoring departments that were under borderline ministries at that time.
So I would take the answer as it pertains resources, but not constitutional or legal, because I am not taking you into a constitutional or legal debate. Or
yes, but the ministry carries its work out in accordance with the constitution and statute.
Of course, and
yes.
So does the court.
Yes, and those are very clear in terms of the limitations of the mandate of the ministry.
Yes, but this is not, we are not speaking of the mandate of the ministry. We're speaking of the responsibility of the ministry as it pertains this order here.
I agree with you that the ministry has responsibility
to
But that
facilitate.
responsibility does not extend to monitoring or supervising departments that are under other ministries.
But it would extend to receiving the necessary information from those institutions.
Why not? Of course, if the information is given to the ministry, we would gladly.
And if it's not given?
accept it. Well, that's where the monitoring and supervising comes in. Is there a duty to monitor to the extent of reaching out and seeking information in terms of how the court order is being implemented? Is that a duty you think the ministry should have had? And if so, based on what?
So, not the way you put it, but the duty is that because the ministry was the applicant, on behalf of the government, of course, the ministry was duty bound to ensure that the order was implemented as the court envisioned. Do you agree with me?
But you see, that's perhaps maybe where we are not reading from the same hymn book. The ministry is a vehicle through which the government made the application.
Yes.
So it was the government's application, not the ministry's application.
I agree.
Yes. So if the government made the application through the ministry and the government obtained the order
Through the ministry.
Yes. And that order is for government departments to take custody of the different assets,
Yes.
then the ministry is in the same position as the other government departments, because the ministry also has the Registrar General under it,
Yes.
who was given assignments under the order. The ministry had Augustus Prom, whom it identified and appointed as receiver.
Yes.
And so the ministry was dealing with its part. There are other government departments, ministries, that were also supposed to deal with their part.
True.
If you see what I mean. So the ministry was just a vehicle to secure the application by the government. And the ministry is part of the government together with the other ministries. So the ministry cannot be supervising what other components of the government were supposed to do.
All right. So I agree with everything you said, except your last statement. Your last statement is that the ministry should not supervise the work of other departments.
Of other departments in other ministries.
Yes. And if the statement is put in that way, I would have to agree with you. Because it is not the Ministry of Justice's mandate to look into the administration or anything of Gilmer or any other institution that is not in its line of work. But the ministry had a responsibility to the government and to the court to ensure that the order was heeded to. And I like the fact that you had painted the ministry to be a vehicle. And that vehicle should have kept running to Gilmer to ensure that the vehicle, because to ensure that MOJ facilitates notice of the order to Gilmer and to wildlife. Because it is true that, yes, the Ministry of Justice was a vehicle for the government to obtain the order. My proposition to you is that it is not, the facilitation did not end at obtaining the order. The end of the facilitation should have been implementation of that order. And precisely why you had instructed your subordinates to form up a team to ensure that implementation was done. Now, the ministry would have not done that if it wasn't, if I can say, the agent of the government responsible for the Janneh Commission or issues surrounding the assets of the former president. And to underscore that point, you see, you've mentioned that the Registrar General was in the loop. I agree with you. That is because he was in the loop even before you went for the order. You mentioned that Augustus Prom did his part. I agree with you because he was in the loop way before you got the order. But you see, the two institutions I refer to were not in the loop before you got the order, and from what this committee has received, they were not in the loop after you got the order. So that's what I am trying to reconcile. And that is where the duty of MOJ and yourself at the time should have kicked in. Facilitation. Now I will do away with monitoring and supervision. I think we can agree to do away with those two words and say that you should have facilitated receipt of the orders.
I hear you. And as you were posing your question, I was thinking, then what would have been the responsibility and the obligation of the line ministries of those departments? Because if the Ministry of Justice was to facilitate, you have agreed to perhaps not use, monitor or supervise, but if the ministry was to facilitate, what would have been the role of the line ministries of these government departments? Because it's a shared responsibility in government. The Ministry of Justice had its part, and these other departments had their part, but they fall under different ministries and not under the Ministry of Justice. As far as the Ministry of Justice is concerned, we had the Registrar General, and I would be happy to take full responsibility for any thing that the Registrar General failed to do in the course of executing the mandate given by the court, and indeed for Augustus Prom as well. But for the other ministry or for the other departments who fall under other ministries, it would be a stretch for me to say that the ministry had any form of role, facilitative or otherwise.
So just to get your perspective, you were saying that the ministry had no duty to put Gilmer or wildlife, the department responsible for wildlife, on notice.
Oh no, not about notice. I did make clear that as far as I know, notices would have been sent through the ministry. So it would be an interministerial correspondence from the Ministry of Justice to the Ministry of Environment and Agriculture, respectively. Now, whether communication cascaded down to the departments, I do not know. But I would want to believe that we would have written to these ministries. If we did not, then it was a gross oversight, if we did not.
All right. From what the committee has received, the MOJ did not. So you do confirm that that was a gross oversight?
If indeed we did not, certainly.
No evidence has been brought forward to the committee that notice was given.
Yep, I'm sure you haven't finished your hearings yet. There may be other witnesses on the way who may be able to provide additional light. Or maybe the Ministry of Justice could, I think they should look into their files. I would be very shocked to know that no official communication was sent. But in any event, if it wasn't, it would have been an oversight, certainly.
And also, on the issue of Gilmer, now, Gilmer, that is Gambia Livestock Marketing Agency, was established by an act of parliament. I believe they have their own board. Now, I don't dispute the fact that their line ministry is the Ministry of Agriculture, but for all intents and purposes, they are independent. Perhaps where the ministry would come in as is convenient in governance is for budgetary purposes. With that in mind, isn't that an institution that could have benefited from direct notice from your ministry?
True, they could have benefited from that notice, even if they were not an independent body. I think it would have done no harm to write to the ministry and CC the departments so that they are in copy as to the order. But as far as I recall, a meeting would have been held at the ministry where all of these departments would have been represented. And because that's the information that I would have had, there wouldn't have been need for me to find out whether they were written to or not, if you know what I mean. Because the assumption at that point is that that meeting would have been held.
I appreciate that. And for the first meeting, the policy meeting that you were in attendance, I can understand why perhaps no records or minutes were formulated. But for the second meeting, I don't believe I would excuse a meeting of that magnitude not having its own minutes or a report.
Well, you know,
Yet this committee is in receipt of no such report or minutes. In fact, since I'm glad that you mentioned that you would take responsibility for everything or anything that the Registrar General at the time
in execution of the
of his
mandate
functions. Of course,
as given by the order.
I see.
Oh yeah, absolutely.
The registrar who wasn't sure whether he chaired that meeting or not had confirmed that there were no such minutes. Were you reported to?
I was not privy to information about minutes. I was not at that meeting. I wouldn't have been at that meeting. It was an operational meeting, and I cannot say anything about that meeting.
All right. Where I'm getting at is, you see, this is an endeavor that began in cabinet.
Yeah.
That's the house of policy.
Mm-hmm.
Now, policy consideration was laid in cabinet, debated, I can assume, and relayed on to yourself, to your ministry. Now, it's that policy consideration that you were acting on. That policy consideration would have morphed into instructions to your team. Am I on track?
Absolutely.
Those instructions for your team to implement, unless, please correct me if I'm wrong, but those instructions warranted reporting back to the policy makers, to you and to cabinet. Wouldn't that be the case?
No. You see, when it comes to implementing policy, so operationalizing policy, that is a matter for the civil servants. The minister deals with policy and issues instructions and gets updates based on the progress of implementation.
Can I just pin you there? Updates. Can you
Yes.
elaborate on the nature of updates?
Well, if there is a significant development, typically the Solicitor General would brief me, typically. Occasionally, other staff members who are dealing with these matters would brief me as well.
In what manner?
Verbally.
Verbally?
Verbal briefing, yes. Verbal briefing. You know, Council, I don't want to keep repeating myself, but you're looking at things
In an ideal situation.
with today's lenses.
Yes.
We're talking about 3 months into the new government, and I don't want to repeat and bore the committee on these comments, but lawyers didn't even have computers to write on. So to assume that we had the luxury of typing out, writing, that wasn't our reality. Our reality was different at that time, and we were making the most of the situation. And so there were verbal briefings to me, occasionally by staff members who were working on these matters, but more routinely by the Solicitor General, who would inform me of significant developments. And if I can just add that at that time, if I recall correctly, and I'm not exaggerating here, if anything else, I am providing you with conservative numbers. At that time, I had no less than 5 meetings with people coming from all over, in and outside the country, a day. Every day, there were visitors flooding this country from abroad, because I guess we were on the news during the impasse. The international community was interested in what was happening in the Gambia, and they were all amused by this little country with